Family-owned business and the Internal Revenue Code, Chapter 14, Part 1 of 3. That is the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC fellow host with today's topic.
Portions of these materials were initially prepared for the 58th Annual Heckerling Institute on Estate Planning, sponsored by the University of Miami School of Law. They are reproduced with the permission of the Heckerling Institute.
This is ACTEC Fellow John Chalice of St. Louis, Missouri. Chapter 14 is a provision in the Internal Revenue Code that deals with special valuation rules for transfers of interest in family-owned businesses. These rules were designed to prevent families from undervaluing business interests when transferring them to the next generation, particularly for gift and estate tax purposes. ACTEC Fellow Todd Anka-Tavanich of New York City will join us for a special three-part series to help business owners and their wealth management and estate planning teams better understand Chapter 14, identify pitfalls, and share recommendations. In Part 1, Todd will introduce Chapter 14 through his Hogwarts mystical rules and discuss how Chapter 14 is contextualized through its basic presumptions and the 4 sections applied to attack perceived abuses. Welcome, Todd.
Well, thanks very much, John, for having me. So, these next 3 sessions, we're going to try to cover from a big picture perspective, Chapter 14 and the various places where you may see it in your practice. I always like to try to conceptualize things with different analogies, and that's no different certainly with the Chapter 14 sort of digestion of the issues. And the way I like to think about it is through a Hogwarts analogy. This was something that I spoke about at the Heckerling Institute last year on Chapter 14. But if we think of the City of London, right? And the City of London in this analogy represents our base wealth transfer objective, right? So what would, a parent typically like to maybe do from a wealth transfer planning perspective, right? They may want to transfer assets. They may want to try to take some valuation discounts. They may want to get assets into some kind of structure that's going to be more tax efficient from a transfer tax perspective and let those assets grow, right, outside of parent's estate. And there's all sorts of variations and techniques that we as estate planners get involved with, of course. And that's, in this analogy, let's say the City of London. That is our base wealth transfer planning objective. Seems kind of straightforward enough, right? We want to get from point A to point B, right? But where sort of the Chapter 14 sort of mystical rules come into play, that is like this kind of Hogwarts kind of ethereal layer, this sort of invisible layer with these confounding kind of rules that just lies on top of the City of London, but it's kind of invisible in many cases, right? And sort of to take this analogy a little further, in this sort of mystical Hogwarts layer, there are all sorts of different rules that don't really make intuitive sense to muggles like us, right? And perhaps, you have some things that like maybe defy the laws of gravity, floating candles and floating cars, or the one that I like to really kind of think about with this analogy is the moving staircase analogy, right? And where are we going with this? Because there is a point here with this Hogwarts analogy. And if we stick with the moving staircases theme for a second, perhaps with this analogy, there may have been way back when some kind of rationale, some kind of abuse that, Hogwarts was trying to sort of prevent. Say, for instance, maybe students were taking a shortcut and going through a restricted area, and they didn't want the students to do that. So to prevent that abuse, they said, we'll come up with these rules and we'll move the staircases. We'll make the staircases move so the students can't go take the shortcut and do this abuse. But unfortunately, you could end up with some very draconian responses or draconian consequences put in place to prevent an abuse. And as a consequence, you can have some consequences that could be much more draconian than perhaps the perceived abuse might justify. Now, with Chapter 14, there are a bunch of different provisions that address different family transactions and perceived abuses with those family transactions from different perspectives. And as we'll get into it, right, sometimes some of the consequences of Chapter 14 are truly draconian, but other times the consequences of Chapter 14 may only be, let's say, potentially draconian. And in certain cases, they may be less severe or less draconian. And that's really going to depend upon the facts and circumstances and the particular rules that we're talking about. But that's kind of a big picture perspective. That's the way I like to kind of conceptualize why we have these kind of, not so intuitive rules that don't really make sense. They're sort of like this mystical layer of confounding rules that can frustrate our sort of base wealth transfer objective. It can frustrate the city of London through this invisible layer on top. And so that's kind of the analogy, and that's the context through which I'll be talking about these things for the next couple sessions, right? So what is Chapter 14? Well, Chapter 14, these rules have now been in place for some 35 years. They are a set of rules that came into place effective October of 1990, right? And they are referred to as the special valuation rules. And despite the fact that they've been in place for 35 years or so now, they still are not very well understood by many practitioners. Or perhaps there are certain parts of Chapter 14 that are understood, other parts that practitioners sometimes will try to avoid like the plague, quite frankly. And, that can be really problematic if you don't have a good handle on these rules, or at least a sensitivity to know where the red flags are. So Chapter 14 consists of sections 2701, 2702, 2703, and 2704 of the code. And these different provisions, like I mentioned before, are broadly designed to attack certain family transactions in order to prevent what was perceived to be abuses in connection with some of these family transactions. And they will kind of attack different transactions from a different perspective or different vantage points. Sometimes you may have a couple different provisions under Chapter 14 that can come into play to frustrate a transaction. But basically, with all of Chapter 14, if you read through the legislative history, there seems to be an underlying assumption that whenever family members, typically senior and junior family members, are getting together to do some sort of transaction, right? Whether that's a partnership transaction, a sale transaction, a gift transaction in trust, or some other types of transactions. Whenever the family members are getting together to do that, there appears to be a presumption under Chapter 14 that the family is working in concert in order to transfer value, at artificially low valuations for transfer tax purposes, and in so doing, trying to cut the government out of its share of taxes. Now, that underlying assumption that appears to kind of be a common thread through the various provisions of Chapter 14, sometimes perhaps that's correct, but oftentimes that's not the case. And I think one of the problems with Chapter 14 is there's just this presumption that when family members are entering into transactions that they are necessarily trying to pull a fast one. And as a consequence, Chapter 14 will impose some consequence that may be draconian in certain circumstances, other times perhaps not as draconian, but still some consequences. So that is sort of the underlying assumption that really sort of is a common thread through all these provisions. Now, let's just talk about what these different approaches are, right? Again, like I said, Chapter 14 comprises of sections 2701, 2702, 2703, and 2704. And I like to categorize these into what we'll call the deemed gift provisions as one kind of broad approach. And then the other ones we'll call the disregarding provisions, right? So the deemed gift provisions are contained under sections 2701, 2702, and 2704A. And they broadly attack certain transactions by saying, okay, we are going to impose some deemed gift upon, let's say, the parent in connection with some kind of transaction that was perceived to be abusive. Section 2701 can result in a deemed gift in connection with, let's say, transfers of subordinate equity interest while the parent holds on or retains a senior equity interest. And as we'll talk about in the next section, 2701 is quite broad in its application. And even though it was really designed to address perceived abuses with discretionary, abusive, preferred, and common partnerships, the language of that provision can spread beyond that. And so Section 2701 comes into play when we're doing things such as carried interest estate planning with interests in private equity funds or hedge funds, preferred and common partnerships when you want to do those kinds of structures, possibly family office, profits interest structures, and possibly sales to intentionally defective grantor trust. The other type of deemed gift provision is under Section 2702. Most people think about 2702 as the statutory basis for a GRAT or for a QPERT. And while that is certainly correct, I think the origin of this statute is really intended to be sort of a punitive provision for transfers in trust where a parent retains an interest and can lead to a deemed gift. Now, the GRAT and the QPERT provisions under 2702 are really safe harbor provisions that come into play. The third kind of deemed gift approach is under Section 2704A, which deals with a deemed gift, or in the estate tax context, an increase in the value of the gross estate in connection with lapses of either voting rights or lapses of liquidation right. And when we say lapse, what that basically means is when that right disappears, when it goes poof. So if you have some kind of transaction whereby either a voting right or a liquidation right disappears or lapses, then 2704A will come into the situation and cause a deemed gift. Broadly, the other kinds of provisions are disregarding provisions. That's under Section 2703 and 2704B. Section 2703 is basically going to say, either for gift tax purposes or for estate tax purposes, certain provisions, they're in some sort of governing agreement, or certain other types of provisions that might sort of cause the value of something to be valued less than fair market value will generally be disregarded for gift tax purposes and estate tax purposes. And that can lead to some real frustrations. The other disregarding provision is under Section 2704B, which is something that often comes into play perhaps with family limited partnerships or family LLCs, whereby certain restrictive provisions that might be included in a governing instrument that would make that would impose restrictions on the ability to liquidate the entity. If those restrictions are more restrictive than might otherwise be provided anyway under state law, then those more restrictive provisions are going to be disregarded for gift or estate tax purposes. And so that's the broad sort of overview of Chapter 14, what it's designed to sort of do, why we end up with these crazy, confounding, mystical Hogwarts type rules, and where we might see it in our practice. And in the next session, we'll go into some more practicality of the session of the different provisions of where we might see them in our practice. So thanks very much, John. I appreciate it.
Thank you, Todd, for your discussion of Part 1, and we look forward to your second and third installments in this series.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit ACTEC.org. Please subscribe to this series and leave us a rating or a review.